This is a Marshall Enterprises presentation. Peace. Welcome to another edition of the Bud-Brownsville Show. Jokes. This is Bud-Brownsville, representing Bud-Brownsville LLC, coming to you today with information about basic trusts. Where do I start? With the basics. What is a trust? A trust is a relationship. A trust is an agreement. A trust is an understanding, and it's best to be documented. All trusts do not have to be documented. You can have an oral trust. The problem with oral trust is proving the categories or the specific duties of the trust. If you have an oral agreement and you say, well, upon this should take place, who are other than the witnesses? And if those witnesses are deceased, if those witnesses are no longer in agreement with you, you have a falling out, how do you prove the basic structure of, that agreement? So you should put it in writing. So you want to decide on what type of trust you want to create. There are hundreds of types of trust, so many different types of trust. So you want to decide on what type of trust you want to create, whether you're protecting property, whether you're just protecting your assets, whether you want to make an agreement or you want to make a situation to happen once something takes place. That could be a death, that could be an inheritance. There's lottery trusts. When you win the lottery, you can form a trust and the winnings go into that trust. But what are some types of trusts? Let me show you some examples. There are revocable living trusts, grantor trusts, irrevocable living trusts, testamentary trust, minors trust, blind trust. Let's stop here for a second. Blind trust allows the trustees or anyone who is holding the power of attorney to handle the assets of the trust without the knowledge of the beneficiaries. These trusts can be useful in situations where the beneficiary should be kept unaware of the contents of the trust to avoid conflicts of interest. That could come in handy to some individuals. And let's keep it going. Here's a third-party special needs trust. The third-party special needs trust benefits individuals with special needs and is intended to hold assets given or bequeathed to such an individual from a third party, such as parents or other family members, and provide for the person's care and comfort after using up government benefits. Without this trust, a special needs individual that receives financially based government benefits may lose those benefits. Here's a first-party special needs trust. Established by a family member, guardian, or the court. This trust helps preserve financial security for individuals with special needs by allowing an individual to benefit from supplementary resources while keeping eligibility for public aid like SSI and Medicaid. Okay, next, number 11, a Medicaid trust. This trust helps seniors avoid tax issues and probate problems when a spouse living in a nursing home dies. This trust protects assets when an individual has too many resources to be eligible for Medicaid. All right, so you want to decide on what type of trust. You want to name the trust. Naming the trust is interesting because the name of the trust does not have to be Bud-Brownsville Trust. A trust can exist and you not even know it exists. There are names of businesses that happen to be a trust. For instance, Pepperidge Farms that makes bread, makes cookies or whatever. Pepperidge Farms is the name that you're presented. Pepperidge Farms Trust owns Pepperidge Farms, or the Pepperidge Farms Trust can be doing business as Pepperidge Farms. Understand? So there are businesses that are trusts that you don't know they're trusts because they don't have the trust after it. 99% of the banks are trusts. TD Bank and trust. Citibank and trust. Chase Manhattan and trust. Almost all of them are trusts, although they go by a different name. So you want to name the trust, and you can even have symbols. Your trust can be a set of symbols, meaning the exclamation point, the number sign, and the dot. That's the name of your trust. Can't nobody tell you what to name your trust or what you cannot name your trust. Got it? So you want to name the trust, you want to name the trustee. The trustee is the manager of the trust. You want to name the beneficiary or beneficiaries. You want to fund the trust. Now, this is a huge topic of which a lot of people don't really understand. When you fund a trust, you do not go and sign the back of your birth certificate and put that into the trust. Because my trust or my birth certificate has $1 billion, you know, it's worth $1 billion, so I'm going to put that birth certificate. No, that's not funding the trust. The terminology for funding the trust is to include, to add assets to a trust. That is what funding is. So if you have a bank account, probably a checking account, you would take your trust to the bank and have them added as an asset of the trust. That's funding. If you have an IRA, a Roth IRA, you want to add that into your trust. You may list it either as a schedule or you would list the trust as a beneficiary, etc. But you want to include those assets into the trust. That is what's called funding the trust. Some people get caught up when you ask them how will they fund their trust, and they're stuck. They're like, well, can I use my salary from my job to put into it? Yes, you can, but that's not the terminology, or that's not the complete idea or definition of funding the trust. Funding the trust is when you put the assets in, or you have the trust control the assets. That's funding the trust. Capiche? You have all the parties sign the trust agreement, trust document, everyone except the beneficiaries. You know, the grantor is the person that creates the trust, settlor, grantor. They create the trust. They would be signing that they are granting, or they are executing or activating or initiating the trust. They will name a trustee. Trustee also has to sign. The document should list who the beneficiaries are. All right? These things need to be signed. Does it have to be notarized? I am going to say no. It does not have to be notarized. And that depends on the state that you're in. These documents are private until you make them public. So the majority of the people that are watching this video, in my opinion, are people that are from this information, public and private, and they pretty much know what I'm talking about. If you don't, you can do your own research and kind of catch up. I don't want to be rude, but kind of catch up. When you make an agreement between two people, you can get witnesses to sign your document. It does not have to be notarized. When you notarize it, it adds a level of officialness to it, so to speak, because if you're using your documents in commerce or you're using your documents in public, the public has things in place like checks and balances. If your document is notarized, it could be proven because that notary has a commission. They were commissioned by someone of authority. When you have a document with 2 signatures on it, who's to say you didn't scribble both lines? So it adds a degree of integrity, but that's debatable. I don't want to get into the semantics and the different craziness with it. Does your trust have to be notarized? No. All. No, not all. Most of my documents are notarized. Most of my other documents, I have several witnesses' signatures that attest to the validity of the document. And let's keep going. I want to show you some more. Credit shelter. A marital trust creates a trust to benefit a surviving spouse and the heirs of the couple. Assets are moved into the trust when the first spouse dies, and the income generated by the assets are transferred to the surviving spouse. When that individual dies, the remaining asset goes to the couple's heirs. And let's go to 21, a generation skipping trust. This trust places assets in a trust designed to transfer them to a grandchildren rather than children in order to avoid estate taxes that occur if the deceased children directly inherit the assets. Okay. I think this is 2 more I wanted to bring to your attention. Very important, very important. You got a Titan trust. This trust allows an individual to put money into a bank account or other form of security to be held until death, when the contents of the account will pass to a designated beneficiary without having to deal with probate. This is also known as a pay on death designation. And finally, let's show you the gun trust. The NFA gun trust allows the maker to acquire the Class 3 weapons and other destructive devices. This trust allows for the transfer of property to and from the trust and for the modification of trustees and beneficiaries. I want to hark on this point for a second. The trustee of your trust must be qualified to possess firearms. If the trustee of your trust is a felon, is someone with a criminal background for whatever reason. I mean, he could be a very nice guy that knows his business, but he cannot handle or be in control of any firearms. And you have firearms in your trust. That is going to be a problem. Your trust should be written, well, if you want to protect the assets, meaning those firearms that are property of the trust, if it is discovered that the trustee cannot handle those weapons will now be, they will be taken, they will be seized, because the trustee who's in charge of those assets are not supposed to be in control of those assets. If the trustee cannot be responsible for those firearms, then those firearms will be seized or removed from that trust, confiscated. Okay, so very important things to think about as you form your trust. Also, there's a lot of individuals that feel that they don't have enough assets or they have nothing that needs to be put into a trust. If you are the owner of firearms, the firearm should not be in your name. It should be in the name of the trust. The trust owns the property, not you. You happen to be the trustee, again, make sure that you're qualified. So these are some dynamics that you really want to consider when you're creating a trust and what type of trust you want to create. Now, if you create a specific trust, or can you combine trust? Yes. You know, it can be 2 types of trust. Is it smart to put or to create a gun trust and another trust? Very smart. Very smart. Separate your assets. The more walls you have, the more work for them to climb. You have just one wall with everything in that. It's just one wall to get in and get to your stuff. What happens if you lose your trust documents? You got everything signed, you got it notarized, stick it either in your safe or you put it in that file cabinet, and the file cabinet gets stolen, safe gets stolen, you have a fire, and both suffer extreme damage. You should have a copy of your trust, or all of your documents for that matter, that important documents, in another location other than just one location. You can have a copy of the trust with all of the beneficiaries. Each one of the beneficiaries should have a copy of the trust. You know, the trustee, of course, is going to have a copy. You as the grantor or settlor may have a copy. If you use a lawyer or an attorney to write or to form your trust or to create your trust, chances are they have a copy. What you may want to do in the event that you do lose your copy, you can get another copy. Let's say the copy that is lost is the one with all the actual wedding signatures, and all you have is copies of it. Most courts and agencies want to see that wet ink signature. You request a wet ink signature all the time when you're, challenging different agencies, but you can take that copy of the trust or that important document to the notary that notarized it, if you had it notarized, and add a simple paragraph on the bottom of the document stating, I know this in my head, but I got to read it, so I'll make sure I says it correctly. This is a true and accurate copy of the trust notarized by me. This is a true and accurate copy of the whatever name of the document notarized by me. If that notary notarized that original document, they can now re-attest that they are certifying that this is a true and correct copy. And now that will have the same weight as the original. Okay? Hopefully I did this some good. Hopefully you have a better understanding, but there are child trusts, there are property trusts, there are charitable trusts, there are irrevocable living trusts, there are revocable living trusts. I can go on and on and on and on and on and on of how many trusts there are. This is why you want to figure out what kind of trust you want to create and follow the steps. All right, so this is basic trust information with the most emphasis being placed on funding the trust. A lot of people do not understand what is meant when we say the trust has to be funded. It's Bud Brownsville signing out. All right, thank you for your time. Thank you for watching, and I'll see you in the next video.